On February 5, 2026, the U.S. Department of Justice announced the appointment of 33 new immigration judges through its Executive Office for Immigration Review. According to officials, many of the appointments were temporary, and a significant number of the judges came from military or enforcement backgrounds. The announcement came against a familiar backdrop: an immigration court system carrying an estimated 3.2 million case backlog nationwide. There was no major press event, no emergency statement from the White House, no immediate response from the Supreme Court. In fact, the news barely registered outside legal and policy circles. To most people, it looked like a routine staffing decision, administrative maintenance in an overburdened system. 33 judges did not sound transformative, and nothing in the announcement altered immigration law itself. That point is important. This did not change immigration law. The statutes, legal standards, and eligibility categories remained exactly the same. What changed was how fast the system is expected to move. The appointments were part of a broader effort by the Trump administration to accelerate immigration adjudication, alongside support for shorter appeals timelines in removal cases. On paper, this was framed as an efficiency measure, reducing delays, clearing backlogs, and restoring administrative control. And in some scenarios, that is how it may function. But immigration courts do more than issue decisions. They coordinate behavior across multiple systems at once: federal courts, state governments, employers, and families planning their lives around legal timelines. Speed does not automatically undermine fairness. Acceleration does not automatically create instability. However, changes in speed can alter expectations even when rules remain unchanged. Courts may respond differently to compressed timelines. States may interpret federal intent differently. Employers may plan staffing more cautiously. None of this happens overnight, and none of it guarantees disruption. The significance of February 5 is not that it marked a policy rupture. It didn't. The significance is that it marked a procedural inflection point, a shift toward throughput in a system where legitimacy depends not only on outcomes, but on process. This is not a story about ideology or enforcement philosophy. It is a story about administrative acceleration and how small procedural changes can, over time, reshape how an entire system behaves. At first glance, speed rarely feels like a threat. Backlogs suggest inefficiency. Delays suggest dysfunction. From that perspective, faster processing appears not only reasonable, but overdue. When a system is overwhelmed, acceleration is often interpreted as competence, evidence that someone is finally addressing the problem. That instinct is understandable. Most people interact with institutions only at the outcome level. A case is approved or denied, a permit arrives or doesn't. From the outside, the internal rhythm of the system, how quickly decisions move, how much time exists to respond, feels secondary, which is why procedural changes tend to pass unnoticed. But institutions do not operate only through rules. They operate through expectations. Expectations about timing, about predictability, about how much margin exists to correct errors or adapt to new information. Speed alters those expectations. A faster system compresses decision windows. It shortens the time actors have to prepare, appeal, or adjust. Courts may feel pressure to prioritize throughput. States may receive less notice before consequences materialize. Employers may face tighter timelines to confirm workforce stability. None of this implies wrongdoing, and none of it suggests that faster is inherently worse. In some cases, acceleration reduces uncertainty by ending prolonged limbo. In others, it introduces a different kind of uncertainty, one tied to process reliability rather than outcomes. This distinction is easy to miss because it doesn't produce immediate signals. There is no single data release that shows expectations shifting. No headline announces that planning horizons have shortened. Instead, adjustments happen quietly. A firm delays hiring. A state prepares for litigation rather than cooperation. A court issues an injunction to slow things down. Each response is rational on its own. Together, they reveal why speed can feel harmless at first, because its effects are distributed, delayed, and indirect. The key insight here is not that acceleration is dangerous. It's that acceleration changes how systems coordinate. And coordination, more than ideology, is what determines whether institutional change remains contained or begins to ripple outward. To understand why this issue extends beyond immigration policy, it helps to reframe what immigration courts actually are. They are not only legal forums, they are coordination infrastructure. Immigration courts quietly help determine who can work, who can plan, and who can commit to long-term decisions. Employers rely on them to assess workforce stability. States rely on them to anticipate social service demand. Families rely on them to decide where to live, study, or invest their savings. In that sense, immigration courts function much like other economic institutions that rarely get described as such: permit offices, licensing boards, or bankruptcy courts. Their value is not speed alone, but predictability. When adjudication timelines are long but stable, actors adapt. Employers hire cautiously but consistently. Workers make plans around known delays. States budget for expected caseloads. When timelines accelerate, the trade-off shifts. Faster decisions can reduce prolonged uncertainty for some cases, but they can also compress planning horizons for everyone connected to the system. Employers may have less time to verify status. Workers may face tighter windows to respond. States may have less notice before enforcement effects materialize locally. This is where economic spillovers begin, not through ideology, but through coordination stress. Consider labor markets. Many industries that anchor local economies, agriculture, construction, food processing, healthcare support, hospitality, depend on reliable access to labor. They do not require certainty that every worker will stay indefinitely. They require confidence that workforce changes will be manageable. If adjudication becomes faster but more uneven, varying by court, circuit, or timing, employers may respond defensively. Some may delay hiring. Others may raise wages to retain workers. Some may invest in automation sooner than planned. These responses are not political statements. They are risk management. Over time, those adjustments can affect prices, investment patterns, and regional growth. Not uniformly, not immediately, but unevenly, concentrated in places where labor intensity is high and margins are thin. Now consider state governments. States operate on budgets and planning cycles. When federal immigration procedures shift quickly, states may struggle to anticipate downstream effects: school enrollment changes, healthcare demand, housing pressure, or labor shortages. Some states may align closely with federal acceleration. Others may build safeguards or resist implementation. The result is not a single national outcome, but a patchwork. For national employers, patchwork is costly. It raises compliance complexity and reduces scale efficiencies. For smaller firms, it can determine whether expansion is viable at all. Finally, consider the courts themselves. Federal courts often become the backstop when administrative speed raises procedural questions. Injunctions, stays, and appeals introduce pauses, not because courts oppose efficiency, but because legitimacy depends on process as much as outcome. This creates a tension that is structural, not ideological. Administrative systems are optimized for throughput. Judicial systems are optimized for review. When throughput accelerates faster than review capacity, friction increases. The big frame, then, is this: immigration courts sit inside the economic system, whether they are described that way or not. Changes in how they operate, especially changes in speed, can influence labor supply, cost structures, state planning, and business confidence. None of this implies collapse. None of it guarantees disruption. But it does mean that what looks like a narrow administrative adjustment can behave like a macroeconomic variable, one that shifts incentives quietly, unevenly, and over time. That is why immigration adjudication speed is not just a legal issue, it is an infrastructure issue. What makes administrative acceleration hard to evaluate is that its effects do not show up where the change occurs. They show up elsewhere, in places that adjust quietly and independently. Start with the economy. Immigration courts influence labor supply not by setting quotas, but by shaping confidence. When timelines feel predictable, employers can plan around them. When timelines compress or vary unpredictably, planning becomes defensive. Firms don't necessarily lay people off or relocate overnight. More often, they slow hiring, rely more on overtime, or postpone expansion. In some sectors, those adjustments can translate into higher costs, Not everywhere, not all at once. But in labor-intensive industries, even small frictions can accumulate. Prices may rise gradually or margins may shrink. Consumers feel the change without a clear line back to court procedures. Now look at supply chains. Local production depends on timing as much as capacity. If workforce availability becomes less predictable in certain regions, firms hedge. They hold more inventory, source from farther away, or automate sooner than planned. These are rational responses to uncertainty. They also tend to reduce efficiency. None of this requires a national shortage. It only requires unevenness. Next, public finances. Faster adjudication does not automatically reduce costs. Legal challenges, detention logistics, emergency staffing, and state-level responses can offset savings. When procedures change quickly, states and municipalities may face short-notice expenses that are difficult to budget for. Over time, those costs can become recurring rather than temporary. Now consider political constraints. Administrative agencies are designed to move faster than courts. Courts are designed to move carefully. Elections reward speed and visible action. Institutions reward legitimacy and consistency. These incentives rarely align. When acceleration increases, courts may respond with injunctions or stays, not to block policy, but to preserve review standards. States may diverge in how they cooperate or resist. The result is not paralysis, but stop-start governance. From the outside, this can look like chaos. From inside the system, it looks like each actor doing its job. Corporate incentives add another layer. Large firms can absorb uncertainty. They have legal teams, diversified labor pools, and access to capital. Smaller firms often don't. When rules feel unstable, capital tends to favor scale and flexibility. Over time, this can accelerate consolidation, not because policy intends it, but because uncertainty rewards size. Finally, there are feedback loops. Acceleration can invite litigation. Litigation can slow implementation. Slowdowns can trigger renewed pressure to accelerate. Each turn of the loop feels justified. The system becomes harder to stabilize precisely because no single actor controls it. Another loop runs through labor and prices. Workforce uncertainty can raise costs. Rising costs can increase political pressure to act quickly. Faster action can increase uncertainty again. The loop doesn't spiral automatically, but it can persist. The important point is this: these structures adjust without coordination. No one plans the outcome. No one needs to be wrong. Administrative acceleration changes incentives. Incentives change behavior. Behavior, aggregated across millions of decisions, reshapes the system. That is why the effects are quiet, and why they are often underestimated until they are already embedded. Escalation in this case does not arrive as a crisis. It unfolds as a sequence of adjustments, each one reasonable on its own, each one responding to conditions created by the previous step. There is no cliff edge, there is a slope. In the early phase, acceleration mostly changes internal rhythm. Immigration courts move cases faster. Appeals windows feel tighter. Judges face pressure to maintain throughput. From the outside, the system appears more responsive. Backlogs begin to ease at the margins. For many actors, this phase feels manageable, even constructive. Employers adjust informally. States observe rather than react. Courts register procedural challenges, but mostly as isolated cases rather than systemic conflict. At this stage, the effects remain largely invisible beyond legal and administrative circles. That invisibility matters because it allows acceleration to persist without triggering broader debate. The system looks like it is working harder, not differently. Over time, however, differences begin to emerge. Faster processing does not move evenly across jurisdictions. Some courts accelerate smoothly, others slow as legal challenges accumulate. Appeals land in federal courts at different speeds, producing pauses in some regions and momentum in others. States respond based on their own labor needs, political incentives, and legal risk tolerance. Some align closely with federal enforcement priorities. Others introduce additional safeguards or resist cooperation. What forms is not paralysis, but fragmentation. Employers begin to notice. Workforce planning becomes less predictable across state lines. Hiring decisions grow more cautious. Expansion plans favor regions where timelines feel clearer, not necessarily where demand is strongest. Larger firms adjust with relative ease. Smaller firms struggle to absorb uncertainty. Automation, outsourcing, and consolidation begin to appear earlier in planning cycles, not because policy demands it, but because uncertainty rewards flexibility and scale. The system still functions, but it functions less smoothly. As this pattern persists, expectations begin to shift. Immigration adjudication is no longer treated as a neutral background process. It becomes something actors monitor closely, anticipating change with each legal challenge or election cycle. Courts remain engaged, but legitimacy debates become recurrent rather than exceptional. Employers incorporate immigration risk as a standing variable rather than a temporary disruption. Labor markets adapt accordingly. Some sectors shrink or restructure. Others concentrate geographically. Regional disparities widen, not abruptly, but steadily. Communities dependent on labor-intensive industries feel the change first. Entry-level opportunities become more uneven. Planning horizons shorten. None of this requires a single triggering event, but certain developments could accelerate the process. A major court ruling could narrow or expand executive discretion. An election cycle could intensify pressure for visible enforcement. A broader economic slowdown could expose labor shortages and price pressures at the same time, forcing trade-offs that had previously remained abstract. At the same time, collapse is not inevitable. The same forces that drive escalation can also prompt recalibration. If costs become visible enough, economically, legally, or politically, institutions can respond. Courts can clarify boundaries. Agencies can adjust procedures. Legislators can intervene, though often slowly. The reason this latter matters is not because it predicts failure. It matters because it shows how normalization works. Each step feels survivable. Each adjustment feels rational, but together they can harden into structure. The central risk is not speed itself. It is the duration of unresolved uncertainty. The longer systems adapt without recalibration, the more difficult reversal becomes. That is how a technical change evolves into a systemic one, quietly, incrementally, and without any single moment demanding attention. History doesn't give us blueprints here. It offers patterns. One useful mirror comes from the United States itself during the early 2000s with Operation Streamline. The goal was speed, processing large numbers of immigration cases quickly to restore control at the border. At first, it looked administratively effective. Case throughput rose. Delays fell. But over time, courts became overloaded, legal challenges increased, and the system quietly shifted from deliberation toward processing. The lesson wasn't collapse, it was normalization. Once speed became standard, reversing course proved difficult. Another partial mirror appears in the United Kingdom during the Windrush era enforcement tightening. Administrative rules were hardened and timelines shortened in the name of compliance. The system worked until errors accumulated and legitimacy eroded. What followed wasn't immediate reversal, but years of remediation, compensation, and institutional repair. The costs arrived long after the policy moment had passed. A more distant but instructive parallel comes from Australia's fast-track asylum reviews in the 2010s. Acceleration achieved short-term deterrence, but it also produced persistent legal, reputational, and diplomatic friction. The system adapted, but at a higher long-term cost. What looks similar across these cases is not ideology, but mechanism. Acceleration first appears technical, then becomes structural. What's different in the U.S. context is scale. Millions of cases, deep labor market integration, and a federal system with strong courts and divergent states. That makes analogies useful, but imperfect. The United States is more resilient than these examples suggest, but resilience often delays consequences rather than preventing them. History's caution is modest and specific. When speed becomes a governing signal, legitimacy and coordination tend to lag, and catching up later is harder than it appears at the start. For most people, this issue never presents itself as an immigration court story. It shows up indirectly through small changes that feel disconnected from policy. For middle-class households, the first signal is often cost. Many everyday services, Food production, home repairs, childcare, elder care, hospitality depend on stable labor. When workforce availability becomes less predictable, employers adjust cautiously. In some cases, that can mean higher prices spread gradually over time. Not everywhere, not all at once, but enough to make household budgets feel tighter without a clear explanation. Job security can also feel different. In regions where local economies rely on labor-intensive industries, uncertainty may lead businesses to delay expansion or reduce hiring plans. Even workers not directly affected by immigration policy can feel the ripple effects when local growth slows. For retirees, the impact is quieter but more immediate. Fixed or semi-fixed incomes are sensitive to gradual price increases, especially in food, housing maintenance, healthcare support, and personal services. If these costs rise faster than expected, retirees often respond by cutting back or adjusting plans more frequently than they anticipated. Service availability can also shift. Many community-based services that retirees rely on are labor-intensive. When staffing becomes unstable, quality and reliability can suffer, even if demand remains strong. Small businesses tend to feel the pressure earlier. They have fewer buffers and less flexibility. Faster but uneven adjudication timelines make workforce planning harder. Some owners respond by delaying hiring, limiting hours, or postponing investment. Others absorb higher costs to retain experienced workers, squeezing already thin margins. Over time, persistent uncertainty can favor larger firms that can spread risk more easily. That doesn't happen because policy intends it. It happens because uncertainty rewards scale. For future workers, especially those under 30, the cost is often opportunity rather than income. Entry-level jobs in construction, services, agriculture, and care sectors are frequently the first to reflect labor uncertainty. When firms become cautious, training budgets shrink and hiring becomes more selective. Research suggests that weaker early job matches can shape earnings and stability for years, even if conditions later improve. None of these effects are guaranteed, and none of them imply widespread disruption. What they describe instead is friction, a system that still works, but feels harder to navigate. Planning becomes shorter term. Margins for error shrink. Stability depends more on timing than skill. This is how institutional change becomes personal, not through crisis, but through the gradual narrowing of room to maneuver. The most important thing to understand about this issue is not what has changed, but what has become possible. Once speed becomes the dominant signal a system sends, once acceleration is treated as proof of effectiveness, it begins to shape expectations far beyond the original problem it was meant to solve. That doesn't mean the system is broken. It means the system is learning. Institutions adapt faster than laws change. Employers adjust before rules are clarified. Courts respond after pressure appears. States plan around uncertainty rather than stability. None of this requires a single dramatic decision. It happens because actors respond rationally to the environment they perceive. This is why the question here is not whether immigration enforcement should be faster or slower. That debate never really ends. The deeper question is what happens when speed itself becomes policy rather than a tool used carefully within it. A system optimized primarily for throughput can still function. It can even look efficient. But over time, legitimacy, coordination, and trust have to be rebuilt elsewhere, often through courts, markets, or political conflict. That rebuilding is slower than acceleration and usually more expensive. The risk is not collapse. The risk is persistence. A system that adapts around uncertainty can continue for years. It just becomes less forgiving. Mistakes cost more. Timing matters more. Planning becomes harder, especially for those without buffers. None of this is inevitable. Boundaries can be clarified. Procedures can be adjusted. Institutions can recalibrate when costs become visible enough. But recalibration rarely happens early. It happens after adaptation has already taken place. That is why small administrative changes deserve attention. Not because they are dramatic, but because they are durable. They shape behavior long after the announcement fades. If you're trying to understand how policy mechanics quietly shape economic and social outcomes, this is where to look. Not at slogans or confrontations, but at the incentives systems create and how people respond to them. If this analysis helped you see a familiar issue differently, consider subscribing or sharing. The goal here isn't alarm, it's clarity. If this issue evolves, it likely won't announce itself through a single headline. The more useful signals will be quieter. Watch how often federal courts intervene on procedure, not outcomes. A rise in injunctions or stays tied to timing rather than substance suggests the speed legitimacy balance is under strain. Watch employer behavior, especially in labor-intensive regions. Hiring freezes, shortened contracts, earlier automation decisions, or relocation of marginal investment often appear before any official statistics move. Watch state responses. When states begin building parallel safeguards or compliance layers, not to oppose policy, but to manage uncertainty, that's a sign coordination costs are rising. Watch price dispersion, not inflation headlines. Uneven increases in services like food processing, construction, home care, and hospitality can indicate localized labor friction rather than broad demand pressure. And finally, watch language. When officials increasingly frame success in terms of throughput and speed, while courts emphasize process and review, you're seeing a system negotiating its own boundaries in real time. None of these signals predict a specific outcome. Together, they help distinguish between a technical adjustment that settles and a structural change that persists. That distinction is the point of this series, not to forecast crises, but to identify where small shifts accumulate into durable patterns. Because in complex systems, the most consequential changes rarely arrive with urgency. They arrive quietly, measured not in moments, but in habits.